There's a reason they've passed it, and they're asking the governor to sign it. But you wouldn't know that by the mainstream media. Joining us right now is our good friend Hans von Spakovsky. He's the senior legal analyst at the Heritage Foundation. He is also the director of the election reform at Heritage Action and the author of Who's Counting. Hans, welcome back. Great to be with you.
Thanks, Crane, for having me. It's great to talk to you again.
Yeah, well, we have just like an open line, just clicking in. And here's something I had to play for you because it is what we've talked about with the Arizona law. And this is Brian Williams framing the Arizona law, according to newsbusters.org, religious freedom rights bill, akin to segregation. It's cut number one. Roll it.
It's just one state out of our 50, but tonight what's happening in Arizona is being compared by some to the epic battles this nation has fought over lunch counters, separate drinking fountains, and restrooms. Arizona Republican Governor Jan Brewer tonight faces a hugely controversial decision whether or not to veto a piece of legislation. It would give business owners in Arizona the right to refuse service to gays and lesbians, or for that matter to anyone, based on their own religious beliefs.
Hans, Brian Williams says, now we go to Hans von Spakovsky. Hans, what do you think about what I just said?
Well, it's really ridiculous, particularly because what he is criticizing and declaiming, that is the standard. The Arizona law is the standard that applies to the federal government. And if people don't understand what I'm talking about, here's what I mean. Back in 1993, the Congress passed the Religious Freedom Restoration Act. It was signed by Bill Clinton. The House passed it unanimously. And what it said was you couldn't pass laws that substantially burden a person's free exercise of religion. That is exactly what the Arizona law says. It protects folks from state actions that substantially burden the exercise of their religion. There is no difference between Arizona state law and the federal law. If people want to know, well, why is a state law needed? It's because in 1997, the U.S. Supreme Court said that, well, it was okay for this law to apply to Congress and to the federal government. It couldn't be applied to the states.
Hans, despite this, we've seen the NFL saying, hey, you're not going to get the Super Bowl if you go through with this. We played a clip earlier from Chuck Todd in the same way. Do you have someone who understands the law as well as you do, being an expert, but do you have any advice on how this is happening and the way, I mean, it's a pretty big snowball that's been put down the hill, and it's gone pretty long. It's built up now because you have, in essence, what we've talked about before, the idea of being compared, and you just stated the facts. Are we doing, I guess my better question is, are we doing something wrong with the way we're presenting this? Because it seems to me there seems to be an absolute distortion of what the Arizona law is. And once again, the false characterization of those of us supporting it as being the likes of the Westboro Baptist Church or the KKK or the Black Panthers. Your thoughts?
Yeah, I don't think this has been defended correctly. I've hardly heard anybody say, in fact, I haven't heard anyone say, defending it on television or other places, that, look, Arizona just wants to put in place what the federal government has already done. If you said that, people would be going, whoa, wait a minute, what are you talking about? And that would bring up this federal law that was passed unanimously and how this is just similar to that, and it has to do with protecting religion. And I think that would make it much tougher for folks like Brian Williams to be attacking this.
Speaking of marriage, federal judge strikes down Texas gay marriage ban, stayed the decision, but nevertheless, legally, where did this thing, if we're looking for the substance legally for his decision to be justified, does he have it?
I don't think so. What all of these judges are doing is they're taking the Equal Protection Clause of the 14th Amendment, and they're saying that banning gay marriage, banning homosexual marriage violates that. Well, you know, how many thousands of years have we not allowed homosexual marriage? We've been in existence for more than 200 years, and the idea that that would violate the Equal Protection Clause has never come up. All of a sudden, judges are saying it does. Well, I think that's because, from a policy standpoint, they want this to be in place, and so they're basically creating a constitutional right where there isn't one.
Speaking to that, I want to go to what Eric Holder said and play it for you, because I think it would be nice. I know sometimes we're making the same point, but it's important because I want the words to be, I want the Attorney General's words to be, have the rest of the story with Hans von Spakovsky, or the truth meter of looking through the lens of the law and the truth in the Constitution. And allow me to jump a little and skip clip, I believe, 3, and we go to the clip 20. Tell me if it's ready there. I believe 20, clip number 20. Here is Eric Holder speaking to the state's attorney generals about the law. Roll it.
This, after all, is the essential duty to which all of us as attorney generals have been sworn. Not just to win cases, but to see that justice is done. This is the cause that brings us together in Washington this week, working to confront the threats and to seize the opportunities that are before us. And this is the extraordinary task with which the American people have entrusted the leaders in this room, and the challenge that all justice professionals are called to address. Not merely to use our legal system to settle disputes and punish those who have done wrong, but to answer the kinds of really fundamental questions about fairness and about equality that have always determined who we are and who we aspire to be, both as a nation and as a people. These are the questions that drove President Obama and me to decide in early 2011 that Justice Department attorneys would no longer defend the constitutionality of Section 3 of the Defense of Marriage Act.
Now, we'll go to his motivations on the next clip, but Hans, addressing just that, your thoughts on, he is the chief law enforcement officer, other than the president, just under the president, obviously, of the land, making that statement. Hans?
Well, look, he's violating the basic separation of powers doctrines of our Constitution and our governmental structures, because his job and the executive branch's job is to defend laws passed by Congress. He's basically saying that Congress can pass a law, but if he decides that, and the president decides that they don't like it, they don't think it's constitutional, why, they won't defend it, and of course then it easily gets thrown out by the court. And that is a way of basically negating the legislative branch, and it's completely wrong. It shows a contempt for the rule of law and a contempt for his duties to uphold the Constitution, which is quite the opposite of what he says he's doing.
Yet he said that he was motivated by a decision by the court, and here is the rest of the Attorney General earlier this week. Roll it.
Our actions were motivated by the strong belief that all measures that distinguish among people based on their sexual orientation must be subjected to a heightened standard of scrutiny, and therefore that this measure was unconstitutional discrimination. And last summer, the Supreme Court issued a historic decision in United States versus Windsor, striking down the federal government's ban on recognizing gay and lesbian couples who are legally married. Now, any decisions at any level not to defend individual laws must be exceedingly rare. They must be reserved only for exceptional, truly exceptional circumstances, and they must never stem merely from policy or political disagreements, hinging instead only on firm constitutional grounds. But in general, I believe that we must be suspicious of legal classifications based solely on sexual orientation, and we must endeavor in all of our efforts to uphold and advance the values that once led our forebears to declare unequivocally that all are created equal and entitled to equal opportunity.
Okay, Hans, he goes to the Windsor case and then goes to motivation, says it's select, and that was our motivation behind, and then we should look at the language. There seem to be some contradictions within his statement, but your thoughts?
Well, he really needs to go back to law school, and he should also start by rereading the Windsor decision. The U.S. Supreme Court did not recognize homosexual marriage, did not say that bans on it violated the Equal Protection Clause. The only thing the U.S. Supreme Court said was that the federal government has an obligation to recognize marriages that are considered legal under state law. That is a very different concept and a very different principle than what he is citing it for. He's citing it for things that the Supreme Court didn't say, and he's using that as an excuse to basically ignore the law and not fulfill his obligation to defend it in court.
Hans, wild card here. I know we're in overtime, but I have to ask this question because Wolf Blitzer had on Jeffrey Toobin regarding his article on Clarence Thomas and the fact that Clarence Thomas hasn't asked a question in years. And he was, number one, I wanted to highlight how the mainstream media takes a constitutional expert and a lawyer and says, okay, this is the person we're going to put out front. And here is CNN's Wolf Blitzer doing just that. Toobin called Clarence Thomas disgraceful, and Wolf Blitzer, according to newsbusters.org, said hailed him for it. Roll it.
It's now been 8 years since Supreme Court Justice Clarence Thomas has asked a question during the Supreme Court's oral arguments. And writing in the new issue of the New Yorker magazine, one of the country's top Supreme Court experts calls Thomas's behavior, quote, embarrassing and disgraceful. That expert happens to be our own CNN senior legal analyst, Jeffrey Toobin, who's joining us now. An excellent article in the new issue of the New Yorker.
Okay, now, Hans, when we hear constitutional expert, oftentimes we will say this person doesn't have a political agenda. But we've gotten into a zone, obviously, where everything's political, and you've talked about that before on the show of how things can be politicized, okay? I get that. So when that kind of criticism is made, or those kinds of statements, what should be our governor? Give us a lens when we hear constitutional expert or constitutional lawyer that's going to give us this non-biased opinion. What the Hans von Spakovsky lens that we should apply and put over the screen, as so we realize there might be bias or might not be. What should we be using to judge the statement being made?
Well, I almost laughed when I heard Jeffrey Toobin called a constitutional expert. But all you have to do is look at how grossly insulting his article and realize that he's judging Justice Thomas on whether or not he asks questions during oral arguments, as opposed to the massive body of written work that Justice Thomas has put out on hundreds of cases since he's been on the Supreme Court. How in the world can you make a judgment about somebody without referring to the actual written decisions he has made? And I challenge anyone to read the many written decisions he's made, apparently, essentially and including some of his very stirring dissents, and say that he is not a brilliant, good lawyer who really knows what he's doing.
I actually read a book, and pardon me for mentioning another author, but I'm sure you know that Henry Mark Holzer wrote a book on the Clarence Thomas decisions. And it goes into the legal analysis and actually teaches law in a way. And to me, there's my knee-jerk talk show host side that says if Clarence Thomas were a liberal and somebody were making this, they would make it about race,
Yes.
the criticism. We notice Hans didn't go there at all because he doesn't have to. Crane doesn't have to go there, but his knee-jerk talk show host side had to mention it. So just forgive him for that. But the bottom line is I don't go there because it's not about that, and that's what we're talking about. We're going to the substance of the issues, and that's exactly what Hans von Spakovsky does, and that's why we appreciate him so much, because he's giving us a guide. He's teaching us. For more about Hans, I will post his latest, as well as the latest effort by the IRS to censor political speech. Hans, your article on this, we should all read because we are impacted by that big time, aren't we?
We are.
Hans, you've been great. You've been generous with your time once again, going overtime.